Please rise. The Justice of the Appellate Division Supreme Court, First Department. He, your person having business with the appellate. Here, in the defendant, and shall be heard.
Good afternoon, all. Courtroom doesn't look so crowded, but there's still 6.5 hours of requested argument time, and I'm sure you don't want to be here into the evening. So I implore you to ask for the time you need to convince us of what you believe are your strongest points. We are a hot bench. You do not need to educate us about your appeal. In terms of mechanics, when you got 2 minutes left, you'll see a silver light, and then 2 minutes later, it'll be a red light. The red light is really for you folks. Would like you to finish up your argument. Of course, if the panel has questions, that judge will continue asking you questions, and please feel free to answer those questions. People versus Haywood Champion. Submitted. Burgos versus New York City Transit Authority.
Appellate, 7 minutes, please.
Looks like you don't have an adversary. You may have scared your adversary off. Do you wish to submit?
It's totally up to your honors. If you have questions, I'm happy to have you hear my arguments.
I think we're good. Thank you. Submitted. L. Michael versus Lillian G. Submitted. Cooper versus Building 7th. 5, 2, and 5. DeLuca versus DeLuca.
Responding to the question, 3 minutes. The appellant is submitted.
You wish time to argue, sir? Yes. Okay, I will give you 2 minutes. People versus Morris.
For Mr. Morris, appellant.
Now, there are 2 cases here, so just in terms of how we've been looking at it, flower case, flower shop case, Hotel Pennsylvania case. So starting with the flower shop case, how much time?
5 and 2.
5 and 2, you got it?
7 minutes.
5. So it's 5, 2, and 5. And on the second case on Hotel Pennsylvania,
4 and 1, please.
4 and 1 on that. Okay, you got it. You want 4? Okay, you got it too. Marisol Holdings versus Image Airport. No, appellant first, sir. 4, 2, and 4. Nath versus Chemta Moss.
Appellate, 5 minutes, Your Honor.
Howard Benjamin on behalf of respondent, 5 minutes, so I'll submit if there are no questions.
It's entirely up to you. If you want to submit, that's fine. I'll give you 5 minutes if you want 5 minutes. What is it? What do you want to do? Okay, so it's just 5 minutes. Okay? People versus Martinez. Tapia versus Bravo. We got 2 appellants here? So I'm going to give 5 and 2, 5 and 2, and 5. What's that? Okay. Okay, and I just want to be clear that Martinez before was a submission. People versus Saxton? 5, 2, and 5. Bosteron versus New York City Transit Authority. Okay, submitted. People versus Terrell Dupri. 6, 2, and 6. Spiegel versus 226 Realty. You don't have anyone else here. Do you wish to submit or you wish time to argue? I think we're good, so it's your call. So you're going to submit on Spiegel? Okay. Francis versus Klein. 5, 2, and 5. People versus Salgado. You got it. 5, 2, and 5. Walton versus Perez is submitted. Allied World versus AIG Specialty is submitted. And the final case, Jones Law Firm versus J Synergy Green, is submitted as well. First case up is Cooper. You may begin, counsel.
Good afternoon, Your Honors. Jessica Bove for appellants BLDG. Defendants BLDG respectfully submit to the court that the trial court.
Counsel, could you speak up, please?
Could you speak up a little bit?
Oh, I'm sorry.
Speak into the microphone so your voice projects. Thank you.
Defendant BLDG respectfully submits to the court that the trial court erred in dismissing the third-party action against Global Pest. First, BLDG is entitled to contractual indemnification. The contract language for the BLDG contract with Global Pest indicates.
So how do you respond to your adversary's point that the provision is ambiguous? Your argument to us is that essentially its performance of the work is what triggers contractual indemnification. Your adversary says that the final sentences can be read to say there's a negligence trigger. How do you respond to that?
It actually isn't ambiguous. It's very clear that the language of the contract is arising for the indemnity is arising out of the contractual work. And the final clause stating to the extent understood under the understood that the Global Pest will not be required to indemnify BLDG for its own negligence. So the contract is very clear that it's arising out of the work, and there's no requirement based on that language to show that Global Pest was negligent for the contractual indemnification to be triggered.
Counsel, you said that the provision is very clear, and the indemnification agreement ends with one of the sentences in the paragraph about indemnification reads, in the event, indemnification will be limited to any liability imposed over the above that percentage attributable to actual fault, whether by statute, by operation of law, or otherwise. I've tried to parse that every way I could, and I can't figure out what it means. Can you tell me what that means?
Basically, the way the contract provision is, as I read it, is that.
I'm talking about this particular sentence.
Yes, the way I'm understanding it is that the indemnity obligation is arising out of the work. However, if there's any type of negligence by BLDG, there would be some sort of maybe partial indemnification requirements. So the issue is not whether the issue would be whether BLDG is entitled to full indemnification versus partial indemnification.
So counsel, to the extent that there might be typos, for example, in this last sentence. And I refer specifically to the opening part, in the event, where event is not defined, and the language, the above that percentage attributable, assuming for the sake of argument that there's typos in this last sentence, is the court able to clear typos, or is discovery needed?
I don't believe there's typos in the indemnification clause itself. It's very clear that that provision is just there so that Global Pest is not being required to indemnify BLDG for BLDG's negligence. But nevertheless, they are required to indemnify BLDG because the accident arose out of their work. So the claims are arising out of the.
Well, there is no negligence trigger. I mean, that's really your primary argument, correct?
Yes, that is,
it's
yes.
performance of the work.
Yes.
Even if we were to agree with you, you would be only entitled at most to conditional indemnification, correct?
Yes, that is my position, and that is what I even argue in the reply papers. And for that reason, it was an error for the court to dismiss totally the contractual indemnification claims against Global Pest. With regards to the common law indemnification claims.
Why don't you hold that thought? You'll have 2 minutes because there's a new thought you're going to make. So we'll discuss that in reply. Counsel?
Good afternoon. As you're aware, we represent the respondent, Global Pest Control. Our position is, unsurprisingly, that the lower court was correct.
Well, let's just go to the arguments being made here. You argue there's a negligence trigger. Where is that negligence trigger? Because when I read the first sentence, it says that you're going to indemnify essentially injuries arising out of the connection or performance of your work, correct?
Sure.
Okay. The second sentence essentially deals with BLDG's pass-through vicarious liability, correct?
Correct.
Third sentence, the way I read it, and maybe this is where we were all having some confusion, is that it says essentially that BLDG's liability is only going to be limited up to its actual fault, correct?
Correct.
So where is the negligence trigger in this provision?
Sure.
That says that they have to show that your company was negligent with respect to what your exterminator did and built.
So our argument isn't so much that there has to be a showing of negligence. Our argument is that the reading of that last end of the indemnification clause is that Global Pest is to indemnify up to the percentage that it has been found liable.
Right.
In this scenario here, Global Pest, the claims against it have been dismissed, so they've been found 0% liable. Hence, our argument here is that they then do not owe indemnity.
Okay, go on.
Sure. So the we agree that there doesn't have to be a showing of negligence by Global Pest, but it doesn't automatically.
So
if it's triggered,
what has to be shown for them to get indemnification?
I mean, so if they're asking for full indemnification, then they would have to make a showing that they have not been negligent, which we don't believe is
Well, all they're asking for is conditional indemnification, saying after trial, we may be entitled to more than that.
Well, with due respect, the first time we've heard that argument for the conditional indemnification has been in their reply papers here. We've argued the rest of these motions on the basis that they were requesting full indemnification. But
then
so
how do
our
you
position
respond?
essentially is that even if the Global Pest cross motion is overturned, which of course we're not conceding, that the building would still not be entitled to indemnification because there hasn't been that determination of percentages of
So
liability.
you're saying it's premature. Is that the argument?
Essentially, yes.
So, but the response is we're only seeking conditional indemnification. We're not asking for full indemnification at this point because it depends on the variables at trial. Correct?
Correct.
So how do you respond to their request for conditional indemnification?
I mean, I think our arguments would still be the same, that we don't see any negligence for Global Pest here. We think that the motion
that's-
court got that aspect correct. So if there's no indemnification for Global Pest, even a finding of conditional indemnity wouldn't be appropriate.
You are arguing a negligence trigger then?
Well, we're arguing that if the indemnity provision says measures based on the percentage of negligence, if Global Pest is 0% negligent, then how could they?
But if,
No
if
indemnity.
the indemnification clause is triggered by the performance of the work, which is what this says, then what we need to establish is whether or not BLDG is or not negligent, not whether Global Pest is or not negligent. Wouldn't that be the case?
Sure, that would also be the case. And we argue and make points in our papers that there is considerable evidence of BLDG's negligence in this matter. As the
But
building owner.
that is something that cannot be established as a matter of law. It would be something that needs to go to a jury to establish whether or not BLDG was negligent, because there was another party,
Sure.
one that dug the trench.
Yeah, and I don't think the decision from the motion court ruled on the negligence of BLDG.
Okay, so if they did not, the only thing that we can do, I believe, would be to restore the complaint, the third-party complaint, because it was dismissed, so that all of these issues go before a jury.
I mean, we would argue that, of course, that the motion court got it correct in dismissing and finding no liability as to Global Pest.
But again, I'm sorry, just as my colleague keeps pointing out to you, you seem to be asserting that since we can't be found negligent here, that therefore the building is not entitled to indemnification, and has been pointed out numerous times, we're talking about performance of work obligations. We're not talking about whether or not you're negligent, which would be a basis also. So go ahead.
Well, I think in that case, then you do run into the potential of a party being indemnified for its own negligence. If Global Pest is found
Are you
to
suggesting that in this kind of service contract, that's void against public policy? Because certainly...
No, we're not suggesting that at all, but that if Global Pest is 0% negligent, then, and if they're then told to indemnify for the negligence of another party.
But if it's not, if you say that it's not against public policy, this is an agreement that you entered into. This is exactly what you agreed to.
Well, they agreed to a contract that they would indemnify up to the percentage that was that Global Pest was found negligent in a situation.
Where does it say that?
I don't see that.
Where does it say that?
So the last sentence, in the event indemnification will be limited to any liability imposed, over the above that percentage attributable to actual fault, whether by statute, operation of law, or otherwise.
Isn't that talking about the building's liability?
Global Pest, and we've interpreted it to be referring to Global Pest's potential liability.
Okay, thank you. Thank you very much.
Thank you.
2 minutes, counsel. Do you want to respond to this argument and then go on to discuss the other stuff, or you want to?
Yes, just to respond to the argument that Global Pest.
Could you get closer to the mic, please?
I'm sorry, just to respond to the argument that Global Pest is 0% liable. The record shows various instances where Global Pest, if not caused the accident, contributed to the accident. They sent the exterminator on a day that was.
So are you suggesting that there is some sort of negligence trigger? What does it matter whether or not there's liability on the part of Global?
Well, that goes more towards the common law negligence. It doesn't really matter on the contractual one, but going back and forth, basically, their argument is that to enforce the contractual indemnification clause would run afoul of the general obligations law. As I discussed, the general obligation law doesn't apply. And
I agree with that. So with respect to common law indemnification contribution, there's no grave injury here. So can you even assert those common law claims against the employee?
Yes, you're correct.
So it's really the issue is the government of your claim is contractual indemnification. You saying you're entitled to conditional contractual indemnification
Yeah.
because they were performing work in the building.
Yes.
Okay, anything else?
No.
Thank you. DeLuca.
Good afternoon. Thank you for the 2 minutes. My name is Robert Smith. I represent the respondent. May it please the court. There are 3 arguments. One, under CPLR 5526, this record on appeal is not complete because all of the appearances before it's a full record on appeal, and all of the appearances before the trial court were transcribed but not produced.
So what's the appropriate remedy, counsel?
Dismiss the appeal. My second argument is that the appeal has been perfected in bad faith. The appellant has quite a history of opening secret bank accounts, submitting
sorry, is
false
that in the
invoices.
record?
I'm sorry?
Is that in the record?
Yes, it is. Yes, it is. The name of the case was Sotheby's against Chewaki, and the appellant against Chewaki, and Judge Kornreich found that there was a lot of really bad behavior.
Counsel, there's a representation that the parties essentially have resolved the issue of the sale of the marital residence.
That's
So
correct.
shouldn't that portion of the appeal be dismissed as well?
Yes.
On that basis
Yes.
alone?
Yes.
Regardless of the other?
That's conceded by the appellant to be a moot point. We're in contract, scrambling towards an October 14th possible hopeful closing. The second argument about bad faith, which I hadn't quite finished, is established by the proof that we have that the appellant is looting the marital estate. Yesterday, I learned that one of the identified valuable works of art was
Wait a
listed
second.
at Christie's.
If you're telling us about something you learned yesterday, my guess is that that's not in the record.
That's correct.
Okay, we don't wish to hear about anything not in the record.
Very well. Very well.
That's something you do downstairs in Supreme Court.
Been there once or twice.
Good.
And actually, when I was there, I learned to revere Justice Gesmer in PS against RO. At the trial level, it would be wonderful if this Appellate Division First Department elevated that precedent on the temporary orders, the automatic orders in matrimonial actions, because I suspect that the appellant is under the impression that the temporary orders and matrimonial automatic orders are not.
Issue before us in this?
I'm sorry?
Is that issue before us today?
Yes, that's the appeal. A large segment of the decretal provisions by Justice Chesler address marshaling the assets, delivering all of the artworks. There's $20 million here that was taken from the marital residence, and providing an inventory and preserving the marital estate.
You're also asking that we dismiss the appeal, so we can't, in that event, we can't reach that issue, right?
If you dismiss the appeal, you do not reach that issue. That is correct. Finally, there's an inherent power in the court, contrary to the argument raised by the appellant about this cavalcade of alleged abuses of discretion by Justice Chesler. The court has inherent power to manage the shepherding of a matrimonial action under Section 236B of the CPLR into a trial-ready posture. If you reach the questions raised by the appellant, which do not contain all of the transcripts, the question would be, does Justice Chesler have inherent power to make the interim orders that he did? Should the CPLR be interpreted liberally? The principal argument by the appellant, as I read the appellant's brief, was that it must be an in hoc verba representation in the trial court of the specific relief that's sought, and that's not accurate. If the court reaches the question of the merits of the appellant's argument and does not dismiss this on the basis.
Thank you, counsel. I think we understand your arguments. Thank you very much. People versus Morris, the flower shop case first, please. You may proceed, counsel.
Thank you. Good afternoon. May it please the court. Marika Meese on behalf of appellant Anthony Morris. I'm going to address the weight sufficiency argument first. In this case, the conduct here did not prove beyond a reasonable doubt an intent to engage in sexual intercourse or even an intent to engage in sexual contact, meaning touching intimate parts of the body for sexual gratification. If you look at the cases cited by respondent—
Is that argument preserved?
No, that is not preserved. Counsel did raise a sufficiency argument as to getting dangerously close in terms of the attempt. He did not frame the exact argument we raised here. Of course, the court can and should, I would argue, reach that in its interest of justice jurisdiction. And also, the arguments apply similarly to the weight argument, which is not required to be preserved.
So why is it you believe that the jury couldn't reasonably conclude that your client intended to rape, it's Ms. Chen, right?
Yeah, to the complainant. Well, there's just not enough here. You have no words or conduct demanding or suggesting anything sexual.
What about just lying on top of her? Wasn't that sufficient on which to conclude, for the jury to conclude that there was something sexual going on?
I don't think so, Judge. Not if you look at the cases that have found sufficient evidence, they're distinguishable.
What was he doing there? He was about to rob this flower shop? Is that what you're saying?
I mean, it could have been other things, but we don't have to prove that, of course. The jury still has to find, and there has to be record evidence of sufficient evidence.
You didn't preserve this, but nonetheless, what about trying to pull her shirt over her head? Let's see, what else? Pushing her down on her back when she tried to get up, positioning himself over her. And that to you does not sound like in any way like an intent to rape.
It's not about whether it's in any way, it's whether it's sufficient. And in the cases where
Let me change my language then. You don't think that's sufficient to establish an intent to rape?
No, I don't.
Pushing a woman back on her back, pulling her t-shirt up, and positioning himself over her body.
Not when you have no discussion or demand of sex,
So you have to ask, you have to say words?
Of course not.
So then where are you going with this about where there's no words?
Well, I'm pointing out all the things that are lacking that are present in cases that have found sufficient evidence.
Counsel, there's also a little bit more, right? Like he grabbed her by the neck and he pulled her from away from the front of the store to probably what is a secluded area in the back of the store. He gets on top of her, then he's tugging at her shirt around her neck area. She felt undeniably that it was an attempted rape. Why isn't that enough?
Well, the subjective belief of the complainant is not an element and not at issue in this case.
But tied with, as my colleague points out, the objective evidence of all the things that he did to put her in the back and get control of her body.
And I would argue still compared to the cases that have found sufficient evidence, it's not enough because you don't have, for example, there's no indication of feeling an erection, seeing ejaculate, demanding sex, touching an intimate.
But what does rape have to do with sexual pleasure?
It has to be an intent.
Pure control, right?
For the sex abuse count, there has to be an intent to engage in sexual contact for sexual gratification on behalf of the actor. So I think it does matter, Your Honor. And even if this might make out the—
Why can't that be inferred by his pushing her down and lying on top of her and trying to lift up her T-shirt? I don't understand
he
why
never
that
reaches
doesn't
for—
show the intent to engage in a sexual act.
He never reaches for her pants or tries to remove her pants or tries to remove his own.
She pushed him off.
But it's not a case about dangerously close. The other attempted rape cases that the people cite in their—
Positioning yourself over somebody's body is not dangerously close?
Well, he's not. It's not a dangerously close argument. He's not over
Are we going to get a yardstick or something? Is that what's needed in order to establish sufficiency?
No, there's more contact of any idea of touching a sexually intimate part. He grabs at the neck of her shirt, never her breasts, never at her crotch area, or never exposes himself, never has an erection, never says anything sexual. He's never actually fully on top of her. He's not straddled her. And in compared to the cases that find sufficient evidence, that is not enough. And her subjective belief isn't at issue here because this is an offense that takes that into account. I would like to turn just very briefly to the ineffective assistance argument for failing to file the Fry motion. This is a case where that single error, based on the timing of this case.
So at the time that this case was prosecuted, would have the filing of a request for a Fry motion would have been successful?
It could have been. Certainly,
I guess
there
anything
was.
could happen, right? But I mean, is it probable, given the state of the law then?
Well, there were split lower court decisions.
Well, wait a minute.
Following.
One case, which maybe was an outlier, obviously ultimately wasn't, but the weight of the authority clearly was that this evidence didn't require a Fry hearing.
But I don't think you can look at the lower court decisions that denied motions without hearings. You really just have one decision going either way, and that left it an open question, and there's no reasonable basis not to have moved.
Go ahead.
How do you address the fact that the customer at the Thai grocery store, Mr. Jiang Sai, testified that he observed the defendant groping Ms. Chen?
Groping generally about the neck area, again, is not a specific intent to penetrate, intent to have forcible vaginal sex. That's what is required for rape 1. I could see perhaps that there's a weaker argument.
Are you arguing that groping does not indicate any sexual intent? You can grope without having a sexual intent?
You could grope someone's arm, you could grope their shorter body. I don't know that it's inherently sexual, and there's no elaboration of where he's groping beyond her own testimony, which is at the neck of the shirt, not her breasts, not her vaginal area, no intimate parts.
Thank you, counsel.
I'm sorry, I didn't know if Your Honor.
We're done. We're good. We're good.
Good afternoon, Your Honor. Sylvia Wertheimer for respondent. As Your Honors have said, the only reasonable conclusion from the evidence was that defendant's attack was motivated by an intent to rape the victim.
What about your adversary's point that the touching was, I guess, in innocuous places? I don't know, and that wasn't sufficient for the judge or the jury to be able to reach that conclusion.
Okay, the touching cannot be viewed as innocuous, but the critical evidence here is that the defendant dragged the victim to the secluded area in the back room, which is something you do when you want to have a sexual attack, pushed her down onto the ground, repeatedly pushed her back down forcefully every time she resisted.
And he also took her into the storeroom, correct?
Took her into the storeroom to a
And why would a person take
area? You don't do that unless they wouldn't have wanted to rob the store. The cash register was at the front. He never asked for money. The fact that there are other cases that have more does not mean that what you had here was insufficient. There's no requirement that there be an express demand to have sex. And I submit also that the victim's subjective belief is very telling here. She was there. She knew, based on her conduct, on his conduct, what he was trying to do. And it's only because she fiercely resisted. And I agree that the fact that the customer across the store was groping her while the victim was lying flat on her back on the ground, the defendant was halfway over her body with his arms and legs touching her. That the only reasonable conclusion as the jury determined was that that was an intent to rape. With respect to the ineffective assistance claim, the case law and record support the 44010 court's conclusion that trial counsel was not ineffective for failing to make a Fry motion that he reasonably believed would have been futile. Contrary to defendant's argument, the 44010 court properly relied on the overwhelming consensus in the trial courts. The Collins decision emerged as a late departure from a consensus that had been prevailing for years. And given that consensus, and indeed defendant's own expert testified that he viewed Collins as an outlier. So it was entirely reasonable to believe that the motion would have been futile. I would also note that the Court of Appeals jurisprudence in this area, Wesley LeGrand, even Williams, specifically contemplates that prior judicial opinions can provide a basis that certain scientific evidence meets the Fry standard. can provide a proper basis for denying future FRI hearings with respect to that evidence. What really changed the landscape here was a decision in Williams, and we submit that this court should follow the Second Department in holding that defense counsel here was not ineffective for failing to anticipate the outcome in Williams. Certainly, it would be incorrect to hold defense counsel ineffective for having a belief that all the intermediate appellate courts also shared prior to what we submit was a groundbreaking decision in Williams. Therefore, I don't know if there are any further questions with respect to that, but there was a great testimony here at the 440-10 at the hearing. Note that the evidence included that the defendant's own DNA expert told counsel, the defendant counsel here consulted with the DNA expert, and that expert told counsel that he thought that the DNA analysis showing the defendant's DNA was on the paper towel was accurate. So that also contributed to the reasonableness of counsel's conduct. For all these reasons, we ask that the judgment be affirmed. Thank you.
Thank you, counsel. Please proceed.
Thank you. Turning back to the ineffective assistance issue, at the time of this case, there were no appellate decisions whatsoever affirming either technique as generally
But there were
accepted.
trial court decisions, at least two as I recall. I think you say one, but there were two.
There was one Magneth on low copy number alone. There was a second Rodriguez on FST alone. And then there was a single decision going the other way, all of which were after hearings that addressed both techniques. So, and zero appellate authority, and the decisions that denied FRI motions without having granted hearings don't really factor into it. But in that open spectrum where you have case law supporting you, no appellate authority, and the case is based entirely on DNA.
What about your adversary's point that the expert retained essentially agreed that it was his DNA? Is that something that we can consider determining whether or not counsel was effective here?
No, Your Honor, because what the expert also admitted is that he was aware of problems with both techniques, particularly low copy number, even made by very reputable people in the field. And since the FRI test looks at the general consensus of scientists, not judicial votes, you had, even in the number of experts on both sides in the hearings that were had, ample evidence of a lack of general acceptance because these experts were in disagreement. That supported a FRI motion. And the Second Department case that people rely on, that case was after, in that case, it was a very different timing because Collins had not yet been decided. So you had a single case after a FRI hearing saying admissible. Our case is after Collins, where you have two adverse decisions equally finding opposite, and there's no reason to not have filed there. As well, this case is more like the Third Department decision in Wilson, where they said that even if it was a far-fetched or colorable at best, that there was no strategic reason to not have filed a FRI motion.
Thank you, counsel.
Thank you.
People versus Anthony. This is the Hotel Pennsylvania case. I'm sorry, People versus Morris.
Good afternoon, Your Honors. Marika Meese again for appellant Mr. Morris. In this case, Mr. Morris raised a seemingly serious request for new counsel, and no court conducted the requisite minimal inquiry that's required by Court of Appeals precedents and decisions from this court. The people rely heavily on the inquiry before Justice Fitzgerald, but he never really gave Mr. Morris a chance to be heard. He disparaged him repeatedly, he dismissed his requests out of hand, and he dissuaded him from saying anything further with comments like, "You're acting up. You have problems. Are we gonna have problems here? You may not be an agreeable, nice person, but your lawyer," and then lauded defense counsel and said that he was, defended him repeatedly. That created an extremely unwelcome environment for him to say anything or to elaborate further. But Mr. Morris did attempt to persist.
Was there any kind of factual allegation serious factual allegation made by your client indicating a breakdown of communication?
Yes, Your Honor. I think collectively, through the various judges before whom he made his request, he showed that he didn't trust his lawyer, that they weren't communicating, even in the minimal
Those are very general statements. Is there anything more specific than that?
Yes, he said that he had filed a lawsuit against him, that his lawyer had failed to investigate and get defense
Well,
evidence.
the issue of filing a lawsuit against his attorney didn't actually take place until several statements later, at later points in time, right? That he had filed the lawsuit. Wasn't this just a recurring statement that had no meat behind it?
It's unclear because no judge took that paperwork in hand and examined it, and it wasn't part of the appellate record.
He had paperwork in hand?
Yes, he had paperwork he numerous times tried to hand up to the court, which the court rejected, or which counsel refused to hand up on his behalf.
Did he ever say on the record, whenever he made one of these applications, what the basis for any lawsuit that he would have filed against his attorney was?
Some of his allegations were that his lawyer had been ineffective once the first trial had happened, and that
Kind of
that lawyer
general.
had failed to investigate issues in that case. And having lost the first trial and being forced to continue with the same lawyer where he now wasn't communicating and had concerns about his effectiveness, that was voiced to the best of his ability and the limited opportunities he had.
But as Justice Getzmer asked previously, what specific complaints did he have about this lawyer? Because
he failed to investigate. He failed to get defense evidence in the other case. His lawyer wasn't fighting for him. He didn't trust his lawyer. Those things are similar to complaints made in cases where the courts have found that there's enough to make it, that's a seemingly serious request that warrants a minimal inquiry. And none was had here. So I think if you analogize it to those other cases, that is enough.
should we consider the fact that these requests were made on the eve of trial?
They were not, Your Honor, because the first request was made on the day that he was arraigned on this indictment. So it can't possibly be on the eve of trial. And then he proceeded to trial on the other flower shop case. After that case, at every opportunity he had when he was brought before court, he made and renewed his request for new counsel. So the timing is not a concern, and certainly...
Also, it's true that the defendant did renew his request, but what's lacking is any specificity, other than the defendant saying that he didn't trust him, that he screwed him, and that he didn't fail to get evidence. And the evidence, I think, was about a 911 call, is that right?
There was a 911 call, there was DNA evidence, there was some...
But I think specifically it was about the 911 call, and I believe the 911, no one got the call. I'm not sure what it is, but the point is he never went into details, and from my reading of the record, he wasn't prohibited from explaining that. And with regards to the lawsuit, the attorney made the comment that that was news to him, right? So a defendant can't drum up a lawsuit to create a conflict.
I don't think there's evidence that was done here, and what I'm suggesting is that Mr. Morris might have had more to say, as evidenced by the little bit he was able to get out. None of the subsequent courts after Justice Fitzgerald really gave him any chance to say anything, because they all said, this was already decided, it's been handled. His own lawyer took statements against him and said, this has been decided.
Counsel, didn't Justice, I think it was Huang, say to him, what else do you have to say regarding the ineffectiveness, the reason for your new lawyer? And he didn't...
Yes, Your Honor, that's true. He essentially asked, what is new here? And Mr. Morris persisted in saying, nothing is really new. I've been making the same complaint that I would like to detail further that no judge has ever really heard.
Well, that was his opportunity to basically detail what his complaint was.
The court didn't invite him to say anything new. It just said, I'm not going to hear you. This has been resolved. And he did agree that he wasn't raising anything particularly new because his complaints were the same as they were before.
Thank you, counsel.
May it please the court, Milan Chachanda for the people. As just an initial matter, the argument about the lack of a minimal inquiry is an unpreserved claim, but in any event, I'd like to just start off by correcting some misrepresentations about what happened before Justice Fitzgerald. It was before me, 21 pages of discussion. My adversary selectively quotes instances that happened that were not related to this removal for a counsel request. It started on, other times there were discussions about Rosario, about the plea offer, those are other instances. But in terms of when he raised a request for counsel, to remove counsel. From pages 13 to 16, he first starts with, I didn't get evidence. And Justice Fitzgerald has him explain what is it, and then there's 3 pages of discussion that it's a 911 call that he thinks belongs in the case that's ready to go to trial. He even, Justice Fitzgerald asks the prosecutor to state on the record that this 911 call has been deleted because the trial happened much later. He was arrested much later. All that discussion happened 3 pages, and he has an explanation for why he doesn't have this call that he thinks he doesn't have. And then on pages 17 to 18, he continues to say, I don't want him to be my lawyer. And the court says, why is that? Defendant says, he's working with the DA. He's working with the DA.
Also, is a general lack of trust and confidence in your attorney enough to prompt an inquiry?
That is not the law, Your Honor. The law is that you cannot make vague or conclusory allegations of just being frustrated. You need specific factual allegations.
As it's been pointed out, he lost the other case, which I think he characterized it was a case that was in the bag or something like that.
I don't, he just says, I mean.
Would that be sufficient that he's lost confidence in his lawyer in a case that he thought was winnable and he lost it?
But that's not, that's simply not enough to say that you're frustrated with your attorney. Like, what did the attorney do wrong that led you to lose all of your, what specifically led you to believe that you cannot trust this lawyer? I think in the cases cited by.
Losing the first case doesn't cut it?
And first of all, I don't think he even said that. He kept on saying, I didn't get the evidence, I didn't get the evidence. I don't also think that he said, my attorney failed to investigate. I never saw that. He just said, I'm frustrated, he's not representing me. He's not representing me, I don't have the evidence.
What about the comment that he's working with the DA?
Right, so anyway, he says, Justice Fitzgerald says on page, he's working with the DA, he's working with the DA. Justice Fitzgerald says, what do you mean by that? And he says, that's all I'm gonna say. So he's given opportunities to please elaborate. And then Justice Fitzgerald goes on to say, well, you know, I'm seeing this adversarial process go along. This is kind of a ridiculous assertion. Do you have anything more? You're not giving me a good reason. Give me a reason. And that is the same pattern that happened before Justices Burke, and then before Justice Burke also on September 12th said, I need a legitimate reason. And again, he said the thing about like working with the DA without elaborating. And then by the time it got to Justice Obis, he proceeded to not show up for five separate scheduled appearances when both his defense counsel and the people were ready. So, and then I just wanted to also say that there are claims that counsel was trying to undermine him. I do want to point to places in the record when counsel was directly asked on the first occasion that he didn't appear, I assume he didn't tell you that he's a Muslim, that he's not showing up, and that's when counsel responds, no, he never told me that. Same thing with, on another occasion, he says, I didn't get the evidence, and that's when counsel says, Judge, this was brought up before Justice Fitzgerald, and it was denied. So all of these responses by counsel were to clarify the record, state facts, and also
Counsel, I couldn't see anywhere in the record where there was actually an indication that Mr. Morris was holding up a summons and complaint and proffering it to the court. Did I miss that? Was it in there?
He did, and I can't say specifically if he waived it. He did say, I have the papers. Sure, he did say, I have papers. And again, he said that on a few occasions, and as you can tell by the record that I hope I detailed in my brief, he was not shy in speaking up. He just would not say what the basis of this litigation was. And again, the law is you cannot create a conflict with counsel. And as Your Honor, I think noted, counsel was even not aware of that. So he had ample opportunity, and that's the thing. He had ample opportunity to give reasons. When directly asked, why do you think he's working with the DA? He was like, I am not saying more. And again, that pattern persisted. So one other, I have not addressed either of the other issues, but sentencing.
Very briefly.
Just the sentencing is that I wanted to say the claim of vindictiveness is unpreserved, but in any event, it was well justified based on what came out at trial, which was his continuing lack of failure to accept responsibility, his compelling the victim to testify and then disparaging her with his incredible account, and his consistent, persistent in denying responsibility. And he was also told he could get consecutive sentences. So unless there are any questions.
Thank you, counsel.
Thank you so much.
First, a claim that there was a lack of a minimal inquiry does not have to be preserved. There's no way that possibly could be preserved at trial because that's a claim of a pro se defendant seeking a request for new counsel, and the mere request itself and what happened in the record is enough to preserve that. So I'm not sure where the people are going with that, but it doesn't have to be preserved. In any event, collectively, what Mr. Moore said before all of these judges, his attempt to repeatedly hand up paperwork to multiple judges, and just the basic evidence of the breakdown between communication between him and his lawyer was enough to trigger the duty to do the minimal inquiry. I'm not saying it was enough for good cause for substitution of counsel, but Court of Appeals precedent from sides says it doesn't have to be. A judge is obligated.
Didn't the court give your client ample opportunity to explain and to elaborate, and he just refused to do so?
He did refuse to elaborate further on his client working with the DA, but there were many times before Justice Fitzgerald and others where they shut him down and refused to look at the papers and didn't let him say more. So that's not a minimal inquiry. The minimal inquiry, as the Court of Appeals has defined, is supposed to be a probing inquiry about what the subject of the disagreement is and whether it can be resolved and whether the attorney and the lawyer can continue to work together. That wasn't done by any of
Did your
these
client
courts.
ever say or argue that there was a breakdown in communication? Because I didn't see those words or anything akin to it.
It's at least easily inferred from the record. He doesn't even know that the 911 wasn't obtained. He doesn't know that his lawyer didn't challenge the DNA or why he didn't or what had happened in that regard. So he's saying things clearly evidencing that his lawyer isn't talking to him and isn't communicating with him. And I think from that, there is evidence of a breakdown. He didn't explicitly say things beyond, I don't trust my lawyer, I can't communicate with him. And I submit that that could be enough. Just turning briefly to the sentence here and to run consecutive to the other flower shop case is an extraordinarily long sentence for both of these cases, and I would submit that it is excessive and this court should reduce it.
Thank you, counsel. Thank you
you.
both. Marisol Holdings versus Image Airport. Anytime you're ready, counsel.
Good afternoon, Your Honors. If it may please the Court, Armando Lorenz for the appellant defendant, Imagine Airport Ventures. In the case CDR Criances SAS v. Cohen, that's 23 New York 3rd, 307, the Court of Appeals said that, quote, a court has inherent power to address actions which are meant to undermine the truth-seeking function of the judicial system and place in question the integrity of the courts in our system of justice. A judgment was entered in this case against my clients when the plaintiffs misled the trial court. They misled the trial court that a loan was given to my clients. They misled the trial court by saying the note represented a debt that was incurred through a joint venture. They misrepresented the percentage ownerships of that.
So, counsel, I was a little confused. You're saying that the secured note was not a loan?
There was no loan, Your Honor.
There
was no transfer of money. There was no check.
Was any of that pointed out by your client?
Pardon, Your Honor?
Was that pointed out by your client?
Was
in
that
an
point
affidavit?
in the affidavit you're speaking of prior to COVID, Your Honor?
On the initial motion, yes.
Right. No, Your Honor. My client.
So then how can we consider that?
Okay, Your Honor, you can consider it simply because you have the impaired power to address a misrepresentation or fraud.
I mean, essentially that's what you're saying. You're saying there was a fraud on the court.
Yes.
Correct? But
Your client never pointed it out.
Well, Your Honor, my client is not a lawyer. One of my clients was unrepresented. He was unable to go to an argument before the court that was scheduled but then canceled because of the COVID court moratorium. The plaintiff was supposed to notify my client of that. That order was never served by the plaintiff on my client. That's not disputed. So he never had a full opportunity to air his points before the judge.
But he
Remember,
submitted
this is
an
not a lawyer.
Counsel, he submitted an affidavit in opposition.
Pardon me?
He submitted an affidavit in opposition to the motion.
Your
And
Honor,
in that affidavit,
if you look at the affidavit,
exactly.
it's a form that he got at the court when he went on a return date, because he didn't even know that the return date wasn't for an oral argument. And some clerk handed him a piece of paper, and he wrote a line. Obviously,
He could have written more. He could have written more in that affidavit.
Pardon me?
He could have written more.
Your Honor, again, he's not a lawyer. He doesn't know what to do. He didn't know what to do.
But he's a business person, right?
Yes, Your Honor, but he is a person who works in a specific business. He's not in the law in this way.
He engages in contracts and borrows and lends money, and why wouldn't that give him enough sense to, if he's going to court, to hire a lawyer and get someone to help him say what he needs to say?
Your Honor, he could not hire a lawyer because at the time he didn't have the funds. Later, of course, COVID hit, and he didn't know how to get in touch with a lawyer at that point. And he just didn't know what was going on in the case. The case, nothing happened for 9 months. He doesn't hear about this again until April of 2023.
Thank you, counsel.
Good afternoon, Your Honors. Matthew Yag of Davidoff, Hutcher, and Citron for the respondent.
Counsel,
Mayor-
could you then clarify for me, where is the loan? Your adversary says that there was no loan. I asked, was the secured note the loan? And he said, no, that wasn't a loan and no money was exchanged. So could you clarify that? How do you see that?
Your Honor, there was a secured note that is in the record.
It was a pledge and security agreement.
Correct, pledge and security agreement. There was
$450,000.
I'm sorry?
$450,000, right?
That's correct, Your Honor.
And it's signed by Mr. Creighton and Image Airport Ventures, who are collectively described as the borrower residing at the same address.
That's correct, Your Honor.
So was that the loan?
That's correct, Your Honor.
Was there another loan too?
I'm sorry.
Were there two loans? Was that the only loan?
There was collectively one note. The money was advanced in piecemeal. Records showing the various transfers of money that predated the execution of the loan are actually in the record. An affidavit submitted actually on motion sequence 2, which is the motion to vacate the default judgment.
Well, that's not before us.
That's correct, Your Honor.
So let's just focus on the motion before us.
Your Honor, the initial motion for summary judgment in lieu of the complaint included copies of the loan, copies of the security agreement, an affidavit from my client showing that or establishing that $450,000 was in fact transferred to the appellants.
And zero was paid back, right?
That's correct. In fact, they defaulted upon, the appellants defaulted upon the note upon the first payment of interest. And that is also included in my client's affidavit, which is included as part of the record. Your Honors, I believe you started to identify this or at least question my adversary on this, but in their brief, appellants advanced myriad arguments which they improperly made for the first time on appeal. They argue, among other things, that the note was procured by fraud, that Marisol misstated the basis of the alleged note, that Marisol engaged in bad faith in its dealings with the appellants, The appellant's
There's
never.
also an allegation that the borrowers allegedly sought to dissolve the business. What does that have to do with anything?
You're right, Your Honor. In opposition to the respondent's motion for summary judgment in lieu of complaint, a single affidavit was submitted by and on behalf of the appellants in opposition to that motion. And in that affidavit, the sole claim that my client, Marisol, was sought to dissolve the business enterprise, which presumably was a reference to the entity known as SPA, here DFW. As the court below correctly noted, that allegation and that evidentiary showing fails to raise a defense as a matter of law. And let me be clear, that is the only defense which was submitted on behalf of the appellants in the court below on this motion sequence 1, the motion for summary judgment in lieu of complaint.
And nothing prevented the defendants from making all the arguments that they're bringing before the court now?
That's correct, Your Honor. And I will note that the return date on the motion for summary judgment in lieu of complaint was adjourned ex parte 3 times by the appellants prior to finally being heard approximately a year after it was initially noticed for. So yes, the appellants had ample opportunity to seek legal counsel, repeatedly decided to kick the can down the road by showing up in room 130 and asking for an adjournment, stating that they were intending to seek legal counsel and needed more time to do so.
Thank you, counsel.
Thank you.
Your Honors, as to whether my client was prevented from making arguments, yes, he was. He did not have the opportunity to have the oral argument that was canceled before him. That was canceled.
From making arguments in the affidavit in opposition, which he filed, in which the only argument he made is that plaintiff was seeking to, to dissolve the corporation.
Your Honor, the argument was insufficient. I'm not arguing as a matter of law.
So in other words, there was no preservation of the many arguments you're making. Presumably on the next appeal, those arguments have been preserved, correct?
Yes, Your Honor, they are.
And you agree we can't obviously go beyond the record to take a look at those arguments?
I disagree there. I believe you have the inherent power to look at the record, just as was referenced by my colleague, about the news story about what the debt was. Again, he repeats,
Wouldn't it be appropriate for another panel who has that record in front of them to make that decision, as opposed to us overreaching and looking at records not on this appeal?
Well, Your Honor, that obviously is what this panel can do. I would urge that the panel look at the obvious misrepresentations that were made to obtain the judgment and should act on that.
What are the of that argument? We're supposed to just look around for other things that we should consider? I mean, how can we decide what do we look at besides what's in the record before us?
Well, Your Honor, it's in the record, and the record is not in a haystack. It was submitted by his predecessor counsel in the trial court. It's in the record. They came up with an entirely new story about what the loan was.
Which is fine. Why didn't you move to consolidate the 2 appeals then? I mean, you had remedies, correct?
Yes, Your Honor.
Thank you.
Thank you.
Nath. You may proceed.
Good afternoon, Your Honors. James Delicio for appellants. May it please the court. I'd like to focus my time today on 2 specific arguments in our appeal, specifically the motion to dismiss on behalf of appellants pursuant to CPLR 3211 and the motion to dismiss based on the respondent's failure to file a timely complaint. With respect to the 3211 motion to dismiss, respondent filed a complaint alleging two causes of action. The first is legal malpractice. The second is a breach of fiduciary duty based or premised on the same set of facts. Those facts are that the appellant's...
Counsel, we're aware of the case.
Okay, so...
go to the heart of your argument.
The heart of the argument...
Tell us what the Supreme Court you say did wrong.
Yes. So, Your Honor, the respondent cannot, did not nor cannot plead proximate causation with respect to the malpractice claim because her theory rests on that she should have been advised to file for divorce in California. She cannot and could not have filed for divorce in California based on the facts that she alleged. Those would be the facts in the complaint themselves. California law requires to maintain jurisdiction for a divorce that you maintain a physical presence in California for 6 months prior to filing with an intent to remain indefinitely. Her own complaint undermines that by stating that she and her then husband fought over exclusive use of their New York City apartment where they resided. Furthermore, pursuant to 3211, we submitted documentary evidence showing that the respondent's own sworn statements show that neither of them maintained a physical presence.
Well, what's the inconsistency? Because when I look at the complaint and the affidavit, it sets forth a series of documents, insurance policies, and a number of other documents that go to the claim that in fact he was a resident of California at the time. What is the inconsistency? And her affidavit essentially says the same thing.
So I disagree, Your Honor. First of all, the only 4 documents referred to in the complaint, there were 2 tax documents and there were 2 insurance documents. They're the kind of facts that need to be specified, the kind of facts that need to be
It's not a motion for summary judgment, right?
That's understood.
So in essence, you have to show that her claims are utterly refuted. How have you shown that here?
By her own sworn statements, Your Honor. Pursuant to 3211A1 and A7, this court can consider the sworn statements that she made in the underlying action. In the underlying action, she submitted an affidavit in which she said, her whole theory is based on the husband's alleged residence, not her own. Her own affidavit states that the husband did not maintain a physical presence for 6 months prior to September 2019. So to the extent this court can and should consider her own...
She says that, or you're saying that you can infer that from...
You can infer that from the fact that in the supporting affidavit for her exclusive use motion, she sets forth a specific timeline of where the husband was in the 6 months prior to filing for divorce in September 2019. He's all over the world. Furthermore, this is an exclusive use motion with respect to their apartment in New York. To the extent that California requires for jurisdiction an intent to remain in California indefinitely, her own pleadings in the complaint, buttressed by her own sworn statements in the affidavit, refute that because they are fighting over a residence in New York. It's clear that as of September 2019, there was no intent on the part of the husband to remain in California indefinitely. First of all, he wasn't even there, but to the extent, for the sake of argument, consider that he had been there for 6 months, they're fighting over a residence in New York. Those facts alone completely refute any claim that she could have.
Sounds like what you're asking us to do is weigh the evidence, and maybe that's more appropriate on summary judgment?
I disagree, Your Honor. I think there's precedent, including the Warshaw case, where this court has considered on a motion to dismiss documentary evidence and pursuant to those 2 GPLR provisions and have dismissed claims. Additionally, if I have a little bit more time.
Just a minute.
Just a minute. The appellants failed to, they had 20 days in which to file a complaint after receiving the demand for complaint. They took 119 days to file that complaint. The only way that is excusable is if it's viewed to be a meritorious action and the respondent offered a reasonable excuse. She offered no reasonable excuse. The only letter that she submitted in support of her claimed medical reasoning for not being able to file a complaint in a timely fashion was one that says she has a condition that prevents her from appearing in court in person. Nothing to do with her ability to file a complaint. Indeed, she filed an affidavit in response to our motion to dismiss in 11 days. If she can file an affidavit in 11 days...
Was there any prejudice?
I'm sorry, Your Honor?
Was there prejudice to your client?
I believe yes, because here I am.
That's not prejudice.
To the extent I disagree, there are many cases where First of all, I don't believe that prejudice is even a required element. Second, there are many cases in which a failure to file a complaint in under 60 days were dismissed. And so the fact that she took 119 days with no reasonable excuse and without a meritorious action, she doesn't meet the legal standard.
Thank you, counsel.
Thank you.
Tapia versus Bravo.
Good
You
afternoon.
may proceed, counsel.
Good afternoon, Your Honors. Melissa Johnston for the defendant appellant Concepcion. May it please the court. Basically, the lower court erred in denying our motion for summary judgment based on liability.
So, counsel, I'm going to jump right into this. So
Right
I make
ahead.
little pictures with cars.
Yes.
So that I can figure out who hit whom when, right? So from what I saw, what my little pictures show is that Tapia's in the first car and Bravo's in the second car.
Correct.
Right? And Bravo hits Tapia.
Correct. That was one
Rear ends. That's
incident.
One incident, one collision. Yes. And then they get out of their cars.
Correct.
And while they are outside of their cars, the Honda driven by Castillo Sosa hits Bravo.
Correct.
And the fourth car driven by your client, Concepcion, hits the Honda driven by Castillo Sosa.
Correct.
So this case is about the injury to Mr. Tapia, right?
Plaintiff driver, correct.
Who was outside of the car.
Correct.
When the 4 and 3 hit 2.
Correct.
And 2 and 1 were both outside of their car.
Any allegation that the plaintiff was struck based on the subsequent collisions?
No allegations. In fact, all the testimony given by plaintiff himself and co-defendant Bravo indicate there was only one impact between Bravo's car and plaintiff's car, which was the second car. That was the only impact. The subsequent impacts that occurred after never moved Bravo's car forward, never hit plaintiff's car again. The testimony is replete and unrefuted. As a matter of fact, plaintiff didn't even oppose our motion. What plaintiff did do was file their own cross motion against Bravo for summary judgment, which was not decided. My client's inaction, action, there was no proximate cause in causing plaintiff's injuries. The plaintiff was out of the car. He testified to the fact that there was one impact. Bravo testified to the fact that there was only one impact to his car. There was no proximate cause. Therefore, the liability does not rest with my client.
Anything else?
And as far as the motion for renewal and re-argument, basically the basis of our motion to renew was my client's deposition, which was conducted on May 13th, 2023. Not that her testimony offered anything new because she had brain surgery as indicated in the record, so she didn't recall anything.
So it's really, in essence, a motion to re-argue, correct? There's nothing new. It's a motion to re-argue.
She was ordered to appear for a deposition. We finally got in touch with her, and she appeared for her deposition, which at the time that the first motion was made, she had not been deposed. Not that her deposition would have made any difference.
Thank you.
Good afternoon, Your Honors. May it please the court, my name is Eric Tosker from the firm of Kelly, Road and Kelly. We represent the appellant Tatiana Castillo Sosa. Your Honors, I think our argument regarding proximate cause is the same as my co-counsel. My vehicle came into contact. If I can just address, though, the sequence of contact, and it's something that was brought up in the motion, it was brought up on the appeal. The sequence was never contested by anyone who opposed the appeal or the motion, and that is my client had testified that she was struck in the rear first. Her vehicle came into contact with then the Teogenes Bravo vehicle. that vehicle never moved.
Car 4 hit car 3, and then car 3 hit car 2.
Hit 4, hit 3, then 3
then
hit
hit-
2.
then
That's
three-
the sequence
then 3
that,
hit 2.
that no one
Not what I
contests.
said.
I'm sorry?
Not what I said before.
No, you.
It's okay.
That's okay.
But two
just-
didn't subsequently get pushed into
But
one.
I think that's the point to be made, and I don't mean to correct any sequence of I would just say in the record that no one's disputed my client's testimony, that no one raised that as an issue, that sequence didn't occur. But regardless,
But again,
no matter how you look at it,
counsel, again.
yes,
Did the subsequent collisions end up hitting the lead car? That's the
no, Your Honor. According to Mr. Tapia himself, and according to Mr. Bravo himself, Mr. Bravo opposes the appeal.
So if there's no dispute about that,
There's no dispute as to proximate cause.
And there's no dispute that both Mr. Tapia and Mr. Bravo were outside their vehicles when the other two cars collided.
Yeah, I should have brought that up. Yes, I agree, Your Honor. If there are no further questions, then I rest on the brief. Thank you.
May it please the court, Gerard Ferrara for defendant respondent Bravo. I'm not going to insult this court or my colleagues by addressing facts, which Your Honor pointed out rather succinctly.
what's your theory?
Well, it's honestly, it's a partial opposition. One, that it was improper to appeal the motion to renew re-argue. As Justice Singh, as you pointed out, there was no new basis. Counsel argues that Concepcion.
What's the proximate cause? What's the proximate cause?
My argument, Your Honor, is that summary judgment has a heavy burden, and if I'm confused on the facts,
But okay, then the facts seem pretty clear to a lot of people in the room. So what's the confusion you're having?
Well, for one, the order of impact. But
Okay,
again,
you
I'm not
heard your
gonna-
stop. You heard your adversaries say
Your Honor.
that the drivers of the first two vehicles are out of the car. The subsequent collision did not go into car number one. Where's causation under those circumstances?
As you pointed out, Your Honor, there's a question as to whether there was an allegation that something from the car accident that subsequently happens strikes the plaintiff. Again, I'm not going to insult this court and waste.
Where is that question? I don't see it.
Your Honor, I'm not going to insult you or this court or my colleagues. I would argue that it should be affirmed that the renewal re-argument should not have been appealed. As to the rest, I rely on this court's judgment as to the facts.
Thank you, counsel.
Thank you, Your Honors.
Okay, keep it brief.
If I may, Your Honors, just regards to the renewal argument, my counsel's argument was not brought up in any opposition papers. It was brought up for the first time on appeal, which,
But isn't that a legal issue, whether or not it's appealable paper?
well, he should have brought it up in his opposition papers to the motion to re-argue and renew is my argument.
Okay, thank you. Anything else, counsel? I'm not going to bother to change the clock.
I think I can only hurt myself at this point, so I rest on my papers.
Okay.
Thank you, Your Honor.
Folks, thank you very much for your candid statements here. People versus Saxton.
Good afternoon. Sam Claflin of the Legal Aid Society for Kareem Saxton. Mr. Saxton's extraordinary acceptance of responsibility and treatment successes warrant downward departure in this case.
You would agree?
It seems to me that when you talk about his acceptance of responsibility, that's inconsistent with his continuing to say on many occasions that the child acted seductively. That doesn't sound to me like an acceptance of responsibility. It seems to me that he's trying to shift the responsibility to a small child.
Your Honor, there's only one statement in the record consistent with what you just said, and that was from the probation interview pre-sentencing. And so what do we have by the time of the SORA hearing? It's been over 5 years since that time. He has undergone treatment by the time of the SORA hearing. He expressly disavows that statement at the hearing. And the guidelines are clear that the court should look to the most recent evidence of remorse.
Does factor 12, was he given points on factor 12? Because that's the one with acceptance of responsibility, correct?
That's right, Judge.
Was he assessed points?
He was not assessed points there.
So then, wasn't that taken into account?
It was not, because the degree of his acceptance of responsibility far exceeded that contemplated by the REI.
Can you explain what that degree is? Because I think I didn't see it in the record. Aside from completing 2 programs, so he completed 2 programs. What's so exceptional about that?
So Mr. Saxton wrote to the Board of Examiners twice while he was incarcerated, committing to continue his hard work, to better himself, and requesting additional programming to prepare him for release. I haven't seen that in any other case. Further, Mr. Saxton addressed the court at the SORA hearing, and in his statement, he acknowledged that he hurt the victim who had looked up to him. He lamented his, quote, terrible and selfish.
Let's just stop for 1 second. You would agree that SORA exists to protect the community from a defendant in a sex abuse case?
Yes, Judge.
Not to protect the defendant, right?
Yes.
Okay. So here you have someone who sexually abused for 7 years a 5-year-old until she was 12. And at that point, when she's 12, she reports the sexual abuse. How does subsequent remorse make a difference to the community where no one knows what he will be like or who he will be upon release?
So SORA is about predicting future risk of sexual recidivism, and one of the factors that courts look to is acceptance of responsibility. As Your Honors noted, Mr. Saxton was not assessed points because he did meet the bare minimum threshold for acceptance of responsibility contemplated by the REI. Here, his acceptance of responsibility went far beyond that. Again, his letters to the board, his
So you're
statements
saying
here.
that that's a mitigating factor that the SORA court did not consider?
That's exactly right, Judge.
Well, how about the aggravating factor that the SORA court did not consider, which is the length of time that this abuse persisted of a 5-year-old where there was oral, anal, and vaginal penetration?
So the full length of that conduct actually was addressed by the REI. The conduct met the definition of a continuing course warranting factor 4
The
points.
continuing course over 7 years, you think is captured by the risk assessment instrument?
Our position is that it is, Judge. And further, I would note that the prosecution and the board did not seek an upward departure on that basis.
So then if that is the case, don't you think that the acceptance of responsibility is also captured by the risk assessment instrument because he was not assessed any points?
I follow the question. I think these 2 factors operate differently. I think factor 4 describes, criteria that are met that would warrant points, and here those criteria were met. Mr. Saxton was assessed points. Factor 12 is more amorphous. If you look at the guidelines at pages 15 and 16, it actually doesn't lay out, just a minimum kind of criteria that always will, dictate whether points will not be assessed. And so I think that that's one difference in the way those factors operate. But again, further, the board and the prosecution did not see fit to upwardly depart on that basis, and the mitigation outweighs that, even if it was not.
Mitigation outweighs the aggravating factors as described by my colleague here, which I don't wish to repeat?
Yes, Judge, because all that conduct was fully captured by the REI. Again, that's our position. But even if it was not, yes, the mitigating factors did outweigh it. So, again, Mr. Saxton wrote.
Going back to the question I raised earlier, it seems to me that his argument that a downward departure would spare his stepdaughter from public humiliation continues to blame her for his conduct. It would only be humiliating to her if she'd done something wrong, which she didn't. So why isn't his argument based on her humiliation continuing to put the blame on her instead of, as you claim, accepting responsibility?
I don't read that statement the same way. I think he's just trying to say that, any potential notoriety or attention that would be drawn to the case would be detrimental to her, and we would certainly agree with that. I don't think that bears on acceptance of responsibility or whether she was at fault in any way, which of course she was not. I'll pick up the rest on reply. Thank you.
Good afternoon, Your Honors. I'm Mir Kedmati for the respondent.
Counsel, your adversary says these are old statements describing the 5 to, I don't even know how to call it, the child. The child is promiscuous, sexually aggressive, and sexually curious. saying that she had enticed him. Those are old statements that really should not have any bearing on the reduction, I'm sorry, at maintaining level 2. So what do you say?
Your Honor, I think my adversary is correct that the guidelines do say that the most recent statements of remorse are what are to be considered by the court, and that's exactly what happened here, which is further evidence that in no shape or form, despite defendant's absolutely horrible conduct, he was overassessed for what he did. In fact, the
Is there an argument that he was underassessed? I mean, he wasn't assessed any points of factor 13, right? And he clearly had a tier 3 infraction, which would have supported points in the factor 13. And I guess the court offset that with his successful completion of these 2 programs that counsel couches as extraordinary.
I agree with you, Your Honor. I believe he received a very generous treatment from the SORA court. In fact, the fact that the people didn't request an upward departure should not be basis for now to grant a downward departure. As Your Honor pointed out, there was basis for an upward departure. The length of time here is absolutely not captured by factor 4. In fact, when you look at the guidelines, the examples they give for a course of conduct is 2 days within 48 hours or 3 days within in a span of about a week. But here we are talking about 7 years of countless acts of variety of different types of rape of a prepubescent child from the age of 4 to 12. And this conduct took place.
4 or 5?
4 years old, Your Honor. 4 to 12.
Our
Yes.
information said 5, but
Oh, my apologies. My apologies.
it's equally bad.
Yes, 5 to 12 years old. Yes.
Yeah.
Yes, and this conduct happened while the defendant was dating this child's mother, and whenever the mother would go away, he would basically rape his child, and he got away with it for such a long period of time, which really goes to the harm that he poses to the public, both in terms of the likelihood of reoffense as well as the harm that would be caused if he were to reoffend. And Your Honor already alluded to the fact that the acceptance of responsibility was taken into account, as well as the fact that he received another beneficial interpretation of his assessment in terms of the conduct while confined. I'll just say a few words about defendant, specifically about his request for downward departure. Your Honor, this request is really entirely academic at the outset. And it's untimely because the SORA court was actually unhappy about the fact that it had to make a finding on the basis of incomplete record. And defense counsel on multiple occasions in the SORA hearing told the court he apologized for not having produced the parole records or the treatment records whatsoever. There was no evidence of his treatment before the SORA court. And in fact, defense
Is that
counsel...
failure to produce those documents the defendant's fault, or was there a delivery issue?
I believe there was an issue about a week or so prior when perhaps the hearing was supposed to take place, but the defendant didn't remedy that by then. But regardless, the SORA court told defendant that, hey, we don't have a complete record right now. You can make you're entitled to make a request for a modification under Correction Law 168-0 subsection 2 within a year. And defendant hasn't done that for the last 7 years, and he's simply asking this court, much like he asked the SORA court, to grant a downward departure on his say-so. In fact, as I was saying earlier, defense attorney in the SORA hearing, he said that, I haven't seen the records myself, but my client tells me the evaluations were very good. And in People v. McNeil, the Court of Appeals stated that an incomplete record essentially bars a review, and that's what we have here. And last but not least, defendant fails every single step of the Gelati analysis. The factors that they're alluding to are not mitigating factors that were already considered by the assessment. And in fact, there is no such a thing as an exceptional expression of remorse. It seems to be a play on words because there is an exceptional response to treatment. But in cases where that's been downward departure has been granted on that basis, there is a very, very lengthy record about what defendant did in order for that request to be granted. That's not what we have here, and defendant did not make any attempts to remedy the absence of record prior to making this appeal. Unless Your Honors have any further questions, I'll rest on my...
Thank you, counsel.
Thank you, Your Honors.
Exceptional acceptance of responsibility is a basis for downward departure. We cite appellate division cases that have where there was downward departure on that basis in our briefs. They are Maldonado, Escobar, and Brocato. With respect to the disciplinary infraction, briefly, that was entirely innocuous. Mr. Saxton possessed a photograph of a reformed gang leader that he said inspired his own reform. He was assessed no points for that. It's of no moment here. With respect to treatment, the RAI does not consider drug treatment at all. I think that's really important to consider here. So even without the underlying records, Mr. Saxton's mere completion of drug treatment is actually a factor warranting downward departure here, given the role that drugs played in the offense. Mr. Saxton was addicted to multiple drugs at the time, and so his completion of treatment and his sobriety for over 5 years by the time of the hearing are essential to understand his future risk. It shows his introspection and his hard work to better himself.
But isn't the sobriety something that really has to be measured once he's out? We can't really tell, given that he's only been sober while he's been in prison, whether he will remain sober once he's out.
So in the Williams case, this court granted a downward departure, citing in part a registrant's completion of drug treatment. And so similarly there was not, to my knowledge, time in the community to measure that, the sobriety in that context, but nonetheless, this court saw fit to downwardly depart. Again, that's Williams. And so I think Williams also supports that drug treatment is not considered by the RAI. It's actually not accounted for under Factor 12. If your honors will read the guidelines there at 15 and 16. There's no discussion of treatment generally. It's limited to sex offender treatment. And so I think the mere fact that Mr. Saxton completed the drug treatment here is vitally important. So when you take that along with the evidence of acceptance of responsibility, which again, our position is far exceeds that contemplated by the RAI, downward departure to level 1 is warranted. Thank you so much.
Thank you, counsel. Thank you both. People versus Dupri. You may proceed, counsel.
Thank you. Good afternoon, Your Honors. My name is Hillary Dowling, appearing on behalf of Appellant Terrell Dupri. During Mr. Dupri's sentencing proceeding, the prosecutor alerted the court to its concern about Mr. Dupri's statements to probation, which plainly implicated justification and intoxication defenses. This triggered the court's obligation to inquire into whether Mr. Dupri understood those defenses and was waiving his right to pursue them at trial. However, the court failed to make any inquiry whatsoever and proceeded to impose sentence. The exception to preservation under People v. Lopez squarely applies to this case. The court's attention was explicitly drawn to Mr. Dupri's statements asserting possible defenses in open court on the record at sentencing.
So do you have a case that stands for the proposition that you just made, meaning that a statement that's brought to the attention of the court, but a statement that was not made in court either during sentencing or the plea, but was made at the word is escaping me.
In the pre-sentence report?
Pre-sentence report, thank
Yes.
you. That's sufficient to trigger what the judge has to do to follow up.
I think that the cases, both that in Lopez and its progeny, stand for that proposition because the cases, the rule of preservation under the Lopez context specifically refers to whether the court's attention was drawn to the issue. So it occurs when a defendant at a plea says something that negates an element of a crime or presents a defense. That also applies at sentencing, which this court recently held in People.
Hasn't the Court of Appeals ruled that the court doesn't have an obligation when the court's informed that the defendant has alluded to a defense or the negation of an element?
I think that the standard is when a defendant says, as he did here, he was acting in self-defense and that he was drugged at the time of the offense, that's perfectly sufficient to have the court say.
Well, that's more than alluded to, right?
Yes, it is.
So the question is it sufficient then is it insufficient that it happened in a pre-sentence report?
So I think that this case is very distinguishable from the cases that stand for the proposition that statements in the PSR, which are out of court and never make it into the record in open court, the court does not have a sua sponte obligation to.
Right, but that's not this, right? Because the prosecutor brought it up.
Exactly.
Okay, and now the next question is, did defense counsel waive the argument by not saying anything?
No, because Lopez does not require that, that defense counsel say anything. What happens is if a defendant says something and the court should know that there's an issue that their attention is drawn to, that it's the court's obligation to conduct that inquiry. I believe that the situation.
When the court asked whether counsel had anything further to say,
Correct.
didn't the court satisfy its obligation then?
No, it does not.
Why not?
Because the court needed to conduct an inquiry based on those statements asserting two defenses to the crime charged. I think that the situation Your Honor is alluding to is actually something that happened in Lopez, where the court did conduct an inquiry. There were problematic statements stated on the record. The prosecution was concerned with it. The court then proceeded to conduct an inquiry, clarified the record as to the justification defense that the defendant was speaking of at the time of the plea. And after that, the defendant did not lodge an objection to the court's corrective measures. At that point, preservation was triggered. At that point, after the court conducted an inquiry, that is when an objection by the defense has to be wagered. When the court conducts no inquiry whatsoever, then there's nothing more that needs to be said by the defendant.
So, counsel, under these circumstances, okay, let's walk it through one step at a time. So in Prelo, I don't know how to pronounce it, People versus Praileau.
Okay.
Prelo. The court says that there is no duty to inquire regarding a defendant's mention of intoxication in out-of-court statements.
Correct.
Okay, and I believe Lopez is referenced in Prelo. I'm not sure. But here you have the defendant admitting his guilt as to shooting the victim in the leg and the back and having the bullet go through his chest. And he says, I was fighting with him and defending myself. I was drinking at the club and someone slipped something into my drink. That's not stated by, is that brought up by the defense counsel at any point?
It's brought up by the prosecution, which
No, right. But let's start with
Yes.
A before we get to B.
No, it was not.
It's brought up by the defense, it's brought up by the prosecution. It's not brought up by defense counsel. And as my colleague pointed out, when the court says, do you have anything else to say? It's like, no, even though the prosecutor said that he took issue, or she took issue with that part of the defendant's statement that referred to that referred to his claimed intoxication. And so there was an opportunity to say, hey, we need a hearing, we're claiming justification. What happens?
That's not what the law stands for. The law stands for the fact that the court is the one who needs to conduct that inquiry. Once a defendant's statements are put onto the record in open court, this takes this out of the bucket of PSR cases where nobody mentions at the proceedings.
Once defendant, I'm just baffled by what the court's duty is. So the prosecutor made this statement and the judge turned to defense counsel and say, what do you have to say about that? And he said nothing.
Well, the
and
judge...
so I don't understand how much more inquiry, how many more questions he has to ask defense counsel at that point if defense counsel said, I have nothing to say about it.
I mean, I can give examples. I think Lopez is very clear that the court has to say something to explore whether the defendant is aware that these defenses are available at trial and that he's waiving them by a guilty plea. It could be as simple as saying, defense counsel, did you discuss these defenses with your client and is he agreeing to waive them?
But can't it be a strategic decision by defense counsel not to get into a hearing on intoxication or justification?
I don't think it's relevant. I think that in all of the cases in Lopez of his progeny, which I think that this is a very straightforward application of Lopez, it's nothing about what defense counsel needs to say or not. Often defense counsel is silent, and the court's inquiry is triggered by the defendant's statements.
Counsel, in Pastor, the Court of Appeals stated that in the absence of a motion to withdraw the plea, the court had no obligation to conduct a sua sponte inquiry into a statement by defendant reflected in the pre-sentence report that alluded to a possible justification defense.
Yes, and this case is squarely in line with that because his statements within the PSR were never aired in open court on the record.
In Pastor, you're saying?
Yes.
Okay, so that's the difference here in your mind, that the prosecutor brought the statements to the attention of the presiding justice.
As an issue, because they were clearly not in congruence with his admission of guilt. And all of the cases that say PSR statements alone, just in these out-of-court statements are not enough, they all emphasize that it's because it was not in open court during the proceeding and on the record.
When you say in open court and on the record, is that to say that the trial judge was not brought to his or her attention?
Exactly, which is the entire point of preservation here. These were directly brought to the court's attention as an issue by the prosecutor because they were inconsistent. That those statements are inconsistent with his guilty plea. The court, instead of the court did not turn to defense counsel and say any response to that. The court specifically dismissed the prosecutor's concern and said, I take it, though, that there is no factual difficulty with the statements that are made by probation, at which point the prosecution abandoned its complaint. So in combination with the people saying, yeah, he claimed self-defense, but I don't think it's a valid claim, and then the court saying, okay, but I take it there's no factual difficulties, anything for the defense? No.
All of this helps you? All of this colloquy helps you?
It does, because the prosecutor brought defendant statements asserting defenses to the crime to which he pleaded
Defense
guilty.
counsel is queried. I mean, you've indicated, I believe, 3 interrogatories by the court asking the defense counsel, anything you have to say, anything more, anything more. I join my colleagues in asking, what is the duty of the court at that point when defense counsel keeps stepping back? Does the defense counsel's possible strategy have to be challenged by the court?
No, I think that it's not about what the defense counsel says or not. Once the court's duty is triggered, which it was here, Mr. Dupri asserted defenses to the crimes to which he pleaded guilty. Those statements that he made were brought to the attention to the court as an issue. That is when the court's duty is triggered, not to just say anything else. Their duty at that point is to conduct a colloquy with the defendant, saying, are you aware that this is a defense? Are you waiving that as pleading guilty? They could have said, okay, you're claiming self-defense. Did the other person have a weapon? No, which would take away from that defense. Were you so intoxicated that you didn't remember what happened? No, that kind of inquiry. The inquiry, Lopez has never held that the inquiry is sufficient for the court to just say anything. It's their duty. It's their duty that's triggered. And sometimes when they fulfill that duty, preservation comes into play. But when they say nothing, when they move on to impose sentence, then preservation is not required under those circumstances because it was incumbent on the court to clear the record and ensure that his guilty plea was valid.
What about the, I believe that in the record, the prosecutor says that despite the fact that he raised that in the pre-sentence report, those defenses were not available to him because this incident was captured on video, and he shot the victim in the back.
I'm glad you asked that, Your Honor, because it's irrelevant what the prosecutor's subjective view of the evidence is, and it is not the role of the prosecutor.
Right, but right after that is when the court turns to the defense and says, what do you have to say?
Well, right after that, the court says, I take it, though, that there are no factual difficulties with the statements. And then the people said no after they made their claim. But the larger point is that it's not the prosecution's job to conduct the colloquy and their sort of generic subjective view of the evidence, and the court's lack of inquiry itself means that there's no record for this.
But do we need the defense attorney to say, Judge, I discussed this with my client and he was aware of that? Or the fact that the court turned to the defense attorney and said, defend that. Anything to say, right?
That's not the standard under Lopez. It's not. Lopez says that the court has a duty to inquire, not
But then the court turned to the defendant himself.
But that's not the inquiry under any of the cases under Lopez.
And no one, not the defense attorney and not the defendant, said anything.
They're not required to under Lopez and its process.
But what more is the court required to do? That's the question everybody has been asking.
And I believe I've gave some examples of that.
You did.
So the court...
But that's when the court is basically silent, right? Silent. But here the court asked.
No.
The court turned to them.
Right, but all of the cases under Lopez where the type of inquiry is approved and stamped with approval from appellate divisions is when the court turns to the defense and says, you've stated that you were acting in self-defense, and then they explore that. It happened in Lopez. And the court and the prosecutor both said, hey, we have an issue here. So defendant, when you say you were acting in self-defense, did you have an ability to retreat? Defendant, were you so intoxicated? Even in Dozier, which was decided very recently, the defendant himself alluded to the fact that he was intoxicated and did not remember the events. The court would not have been sufficient to say any response. The court was required to say, okay, you've asserted this defense. Do you realize that you're waiving that defense by pleading guilty? When you say you were intoxicated, do you recall the events as they occurred? And if the defendant was to say, no, I don't remember anything, then that plea couldn't stand. That plea would have to be withdrawn at that point. But saying, okay, any response is not sufficient under Lopez. I found no case where they said that kind of inquiry was sufficient. And I don't think it's a very high bar. You could ask a couple questions. I won't say that I would think this is sufficient. As simple as defense counsel, did you discuss these defenses with your client, and is he aware that he's waiving him by pleading guilty? At least that. But he says nothing. He moves on, kind of disavows what the prosecution raised. And the prosecution raised them as issues because they were inconsistent with the guilty plea. Court says, okay, but anything else? No, that is not sufficient under any cases under Lopez that I've read.
Thank you, counsel.
Thank you.
Good afternoon, and may it please the court, Faith DeTrolio for the people.
Counsel, assuming that the court's duty to inquire was triggered, the colloquy that the court engaged in, was it sufficient?
Well, Your Honor, I think as we pointed out in our brief, we would disagree with the premise of the question. However, moving on, I think that this inquiry that the court made with defense counsel, anything else, I think it points to the fact that defense counsel had discussed.
I need you to answer my question. My question is very simple. If the duty was triggered, was the court's colloquy sufficient? Asking counsel anything else, does that cut it?
Yes, Your Honor. I think that inquiry does sufficiently address the potential defenses that defendant was raising in his pre-sentence report. However,
I think the court had an obligation to ask, to make sure that the defendant knew that he was waiving his intoxication defense, that he was waiving any elimination of mens rea. You don't think that the court had to dive into that a little bit more than other than by saying, you have anything else?
Well, defendant didn't make those claims at sentencing.
Clearly, whatever the statement the defendant made was of such trouble to the prosecution that they brought it up.
I would argue, Your Honor, that the prosecutor's remarks pointed more towards the defendant's acceptance of responsibility as opposed to his understanding whether he was...
That's because the prosecution disagreed with his assessment that he had a self-defense claim, right? Because he was shot in the back.
Correct.
But that's not going to be decided there. The issue there is whether he's waiving that defense.
Correct, Your Honor. But I would just like to point out that I think the validity of a self-defense or justification or intoxication defense does point to the voluntariness of the plea. If defendant really did have a strong intoxication or justification defense, he would have discussed that with his defense attorney and elected not to plead guilty. But that's not the case we have here. In this case, defendant was granted a Dunaway, Mapp, Huntley, Rodriguez hearing, and he pled guilty before that even occurred. Defense counsel is making multiple motions on his behalf, and it's clear that when the parties come to the plea, they say, we have a disposition, indicating that defense counsel and defendant...
I just want to make sure that I understand you so that I could frame my next question. But so if during the allocution, the plea allocution, the defendant said, I was drunk, I don't remember, and I shot him because he was about to shoot me. Did the court have a further obligation then?
I would say in that case, yes, because
Okay,
he's
stop.
making the
And
statement.
if the court had an obligation then and the court just turned around and said, counsel, what do you have to say about that? Is that sufficient?
I think it would address whether defense counsel and defendant address these potential defenses in their discussions and in their decision to plead guilty.
So in your position here, did the court have an obligation to inquire?
No, Your Honor.
Why not?
Because defendant did not make the statement in open court, which
What difference does that make? Whether the defendant made the statement in open court or made it in the pre-sentence report or wrote it on a piece of paper, the court was aware of the defendant's statements.
yes, but you could argue that in all the other cases that have been cited, the judge was also aware of defendant's statement made in the pre-sentence report when it wasn't brought up by any of the attorneys. But in those cases, the court found that there was no duty to inquire because those statements were not raised in court. So that's for one reason. For a second reason, defendant, I think you noted before, Your Honor, that there was no motion to withdraw the plea on this, in this vein of the defenses. And I think the record reflects that this plea was voluntary and knowing in other aspects. I think it reflects that defendant wanted to resolve his case with the plea, that the plea agreement was a rational one for defendant. He was facing a life sentence if he was convicted of this, murder in the second degree after trial. The evidence was strong, so there was a strong likelihood that he would be convicted. He was of an age and of experience with the criminal justice system where he was aware of what he was pleading to. The plea was accepted by the trial court, who had presided over all of the proceedings that defendant was a part of. And finally, the claims that he raises in the pre-sentence report were not valid. Just briefly on the excessive sentence claim, defendant's sentence was fair and appropriate and should not be disturbed on appeal. Given the very serious nature of this crime, defendant's sentence was fitting, and he benefited greatly from this plea agreement by avoiding a potential life sentence, and all of the purported mitigating factors were considered by the sentencing court.
So you say that this issue, this defense issue needed to be preserved by making a motion to withdraw the plea?
Yes, I think that's one way the defendant could have preserved this issue. Another was to renew his claim that he made in the pre-sentence report in court. So this is not a defendant that was shying away from speaking to the court. We saw in the resentencing that he himself was opposing the predicate felony statement. He was challenging his identity and the constitutionality of it, along with his defense counsel. So I think this is not a case where a defendant would have, if he had something to say, would have shied away from it. And he was given an opportunity to speak, I believe, before a sentence was imposed, and he declined to speak then as well. If there are no further questions, we ask that you affirm. Thank you.
Thank you. I will briefly address some of the statements by my adversary, and then I do want to quickly turn to the excessive sentence claim because I did not get to that in my first appearance. I will be as quick as possible. The fact that because Mr. Dupri did not speak out of his mouth at the sentencing proceeding has no bearing on the Lopez analysis. The rule as stated in Lopez does not rest on how defendant statements are put into the record in open court. It rests on whether the court's attention was drawn to the issue so that the salutary purpose of preservation is not jeopardized. That's exactly what happened here. My colleague also spent some time speaking about all these other factors that have nothing to do with the Lopez analysis. The case the respondent relies on for that assertion is People v. Conseco, which relates to Boykin rights, and it's a completely different preservation exception. So all of these facts about how long the case has been pending, motions being filed, his familiarity with the justice system, that has nothing to do with the Lopez analysis.
So in Perlew, we say that the narrow exception to the preservation rule, citing to Lopez, doesn't apply because in the plea allocation, there was nothing casting doubt in defendant's guilt, correct?
Correct.
So, and then there were extraneous statements which we didn't consider. What casts doubt about the defendant's earlier plea allocution here, in light of the fact, and I understand your argument that the court has a duty to inquire, in light of the fact that the defendant and his counsel were silent after the prosecution raised their point?
Because that's not a factor that's considered under Lopez. The factor that is considered under Lopez was statements asserting defenses, negating an element of offense, or other casting doubt on the guilty plea were made in open court, whether at plea or sentencing, that is sufficient to trigger the court's duty to
But the defendant said nothing here in open court that would give the court some concern.
His statements were summarized by the prosecution as an issue with respect to his plea. His statements were aired in open court.
Counsel,
I don't think
that's true, but I think what's problematic with regards to that is that if you look at Rojas, people who read Rojas, we said that we have repeatedly held that the Lopez exception does not apply to statements in pre-sentence reports. We so held in Pastor, which I quoted from before, which the Court of Appeals affirmed.
Correct.
How do you get around that?
Correct. So the point is, in all of those cases, that they were out-of-court statements that were never brought into the record.
So that's the distinction for you.
That is the distinction. I think it's a distinction that places, it's not in the bucket of the PSR.
No, but this is an out-of-court statement, too. It was an out-of-court statement in a report raised then by the prosecution. We're still talking, big picture. That's what we're talking about. So essentially what you're telling us is that this line of cases that we've cited to was wrongly decided and should be overruled.
Not at all. Speaking about the PSR statement, the PSR cases, I do not think that those, I have opinions about those cases, but they're not relevant here because all of those cases say
you're distinguishing this case.
I am
Because
absolutely.
This case, what was said in the pre-sentence report was specifically brought to the attention of the judge.
Exactly, which is the entire purpose of preservation. That is the entire purpose of preservation. Said, hey, judge, these statements were made. That's inconsistent with his plea. That triggers the court's duty to inquire. The cases about the PSR, my understanding is that means that trial courts don't need to pour through the PSR report, identify things such as this, maybe asserting defenses or negating an element, and then take it upon themselves to bring it up. That didn't happen. It was brought up as an issue.
Why don't you address?
Thank you very much. I'm sorry. I will be very brief. If this court declines to vacate the plea, we ask that you reduce his sentence in the interest of justice. On his plea to manslaughter, the court sentenced him to 21 years incarceration, just 4 years shy of the statutory maximum. He had no prior history of violence before this, and although he has prior contacts with the system, his record is by no means lengthy, as respondent describes, and his history consists of drug-related offenses connected to his addiction issues. At the time of his offense, he was struggling with PTSD related to his time in the Navy, for which he never received any form of treatment until his incarceration on the instant case. He does not dispute the serious nature of the offense, but under the totality of circumstances here, the sentence of 21 years, only 4 years shy of the statutory maximum, is excessive. I realize that he was facing a life sentence on the top charge. Often these plea deals are negotiated because the prosecution has doubts about proving the top charge beyond a reasonable doubt at trial. The people gave very gratuitous, self-cited information about the strength of their case. That's in dispute. There's plenty of factors in this case and in the evidence that could have led to perhaps a top conviction on manslaughter. So I believe that this case is excessive. If the court declines to reverse on the ground that his plea was involuntary, we do ask that it reduce his sentence in the interest of justice.
Thank you, counsel. Thank you both.
Thank you very much.
Francis versus Klein. You may proceed, counsel.
Thank you. Good afternoon, Your Honors. Dan Goldstein of Smith, Gambrell & Russell, LLP, for defendants, appellants, Parkview Management, Judah Klein, and the 329 LLC. The principal issue on this appeal is whether labor law section 193 applies to this dispute. As the court will certainly recall, plaintiff Ben Francis was employed by Parkview pursuant to an employment agreement. He was initially paid an annual salary of
How do we deal with our voluminous case law that an outright refusal to refusal to pay a bonus doesn't come under Section 193.
How do we deal? Well, this court has dealt with that issue half a dozen times over the last 5 or so years, holding repeatedly that a wholesale withholding of a payment, particularly a disputed payment, is not a deduction from wages under Section 193 of the labor law. And it's not just this court that has held this way. This court is not on an island. I want the court to, understand that. I think the respondent's brief tried to paint it that way. Other appellate departments also hold that a wholesale withholding of a payment is not a deduction. Federal courts have held a wholesale, all of the federal courts, as far as I know, in this state hold that a wholesale withholding is not a deduction. The Second Circuit has held that a wholesale withholding is not a deduction. And most importantly, Ryan, which is what the lower court relied upon to hold inconsistently with this long line of precedent, Ryan does not hold that a wholesale withholding is not a deduction.
Ryan was Section 193 even at issue?
Ryan, I don't know if, honestly, I don't know, because all of the, if you read the case, it says the plaintiff is bringing a claim under Section 190 through 198. And it just holds that in that particular case, under those specific sets of facts, which are highly distinguishable from the sets of facts in this case, I mean, completely different types of cases. Under those circumstances, the court held that the penalties and the remedies of the labor law applied. That was a case where basically the court found that this individual was induced from his prior company to work for this new company and was promised your wages will be split into 2 parts. You have your salary and you have your guaranteed bonus. That is your wage. And when part of that, perhaps when part of his wages were deducted, it held that the labor law applied. In this case, I mean, your honors are familiar with the facts. I won't go through it all, but as you know, if you just look at the pleading on it's in the record on page 57, it's paragraph 14 of the pleading. The principal allegation is that on January 14, I'm quoting, on January 14, 2019, the night before the LPC hearing, after all of the work had already been done, plaintiff and Klein agreed that if the LPC grants the SUL, plaintiff would receive $250,000. I mean, there are multiple reasons that this is not a wage. First of all, it's conditional on the SUL being granted by the LPC. Wages that are, well, as you know, there are 2 principal arguments we make.
Well, also, unlike in Ryan, the parties here seem to never really come to an agreement as to what that bonus is going to be.
Absolutely. You know, that is not really, our position is that there was never a meeting of the minds. This allegation that the night before a huge hearing, my clients agreed to pay $250,000.
Isn't that in writing, counsel?
Isn't that a writing?
Doesn't Mr. Klein agree doesn't he say, I agreed to pay you $250,000?
It's an issue of dispute. It's not quite that simple.
I'm asking you, isn't there a writing that reflects that?
Not quite. He does say that, but it's in an exasperated manner as they are negotiating.
I guess what I'm asking you is that, was there an agreement as to the amount of the bonus, but a disagreement as to the manner in which it would be paid? Or was this a discussion that was not finalized?
It's both of those things. It was a discussion that it was never finalized, and it was it didn't start out as a $250,000 payment. The first
started out as an apartment.
As an apartment, right? And then
give me an apartment in the new building.
Right, and that offer was rejected, and then they didn't talk about it again for 5 months. This was a 6.5-month project. And the night before the ultimate hearing.
Thank you, counsel.
May it please the court, Jack Nunes for plaintiff respondent. On the issue of the contract, whether a contract exists, first off, there's a material issue of fact, but also that really wasn't raised. What
I'm trying to understand how Ryan applies here. Because sure. Ryan, it was clear that the bonus was a term, condition of him being induced to leave his former firm to come here. In this case, the point I guess I was trying to get out was that the parties were negotiating. Sure, there's a writing about 250, but there was a course of conduct, a negotiation. So the question is this a term and condition of the employment like Ryan was?
Sure, but first, whether it's a term and condition of employment from the start of employment or in the middle of employment, it really is irrelevant, because the question is whether it is a wage, and at what point in the employment the bonus comes about or is promised or becomes something that could be vested and earned is not really at issue. Ryan is actually incredibly identical to this case because it was also an oral agreement. All the evidence at trial in Ryan was testimonial evidence. It was incredibly disputed, just like in this case there's a dispute, except that in this case there's a text
Did
message.
Ryan address Section 193? Well, I read it. I didn't see much of it. I didn't see any discussion, quite frankly, on Section 193.
Substantive discussion on the term deduction within Section 193? No, but there is, at the end of the decision, they held, Ryan expressly stated that because the bonus is a wage, it is the defendant violated Section 193, and it explicitly identifies 193, and thus the plaintiff was entitled to all the benefits of Section 198, the remedies within 198 1A, which is important to distinguish because 198 1A and 198 3 are different sections within Section 198 of the labor law. But yes, Ryan explicitly identifies Section 193, and I would state that there are compelling justifications for reversing Perella. I understand it's been affirmed numerous times, but there is a split in the departments at this point. 3 of the departments, one of them, the second department cites to Ryan in its decision. The 4th department in Zinno explicitly distinguishes Perella by identifying it as contrary, as differentiating authority. The 3rd department in Kuiper, which was issued after the Kettler decision, that held that under Section 193, bonuses could be recovered. And so the 1st department is the only department currently within the appellate division that has held that Section 193 cannot be used to recover wholesale withholdings of wages. And in addition to that, there are other reasons why the stare decisis should be reviewed is that there's a distinction between wholesale withholding and a specific withholding, which is read into the statute. There's nothing specifically in the statute that talks about wholesale withholdings or specific withholdings. It just uses the term deduction. Because that's being read into the statute, just like at Wiggins, the 1st department case that was cited, it's the same exact thing that happened there. There was an exception to a statute that was read into it, so it added justification to revisiting Perella. The 3rd reason is that there is underlying legal authority that Perella relies on. Every single one of those cases, and it looks like there's a lot of cases there, but if you track each and every single one of those cases, it goes back to 2 cases. That is it, and that is the Miles Kettler decision and the Hudax decision. Those are the only 2, and neither one of those address this issue of wholesale withholding. Both of them deal with a different issue, not what is a deduction, but whether the item that was deducted is a wage itself, and both held that they're not wages. So this entire body of case law is no longer is based on these 2 decisions. In addition to that, a finding that a wholesale withholding is not covered under Section 193 leaves a large portion of prior to the 2021 amendment, of course, leaves a large portion of the population in New York within the 1st department without a remedy.
Well, the law has been amended now.
Yeah, I mean prior to 2021, but it's a 6-year statute of limitations, so there's still 2 years left on where causes of action could be accrued, and also there are cases like Mr. Francis's that are currently going through the pipeline, and because he's excluded from Section 191 of the labor law, he can't pursue his unpaid wages via Section 191. His only option is Section 193 and 198, and 198 has repeatedly been held to be just a remedies provision, which, as we argue, it's not. But to make a long story short, Section 198 explicitly states that all employees shall have the right to recover full wages, benefits, and wage supplements and liquidated damages accrued during the 6 years previous. If Mr. Francis is not permitted to recover this wage, assuming that the court finds that it is a wage, then he simply will not have this right that is written directly into the statute. I would just like to make an important point, which is on whether something is a wage. The holding in Colchins, the Court of Appeals decision in Colchins, is directly on point, where an individual is tasked with managing a particular division, then a bonus is based on their performance, even if there are other individuals that are involved in working. So in Colchins, the manager was in charge of a trading desk, and his bonus was based on the net earnings of the trading desk. Of course, there are other individuals that are working on the trading desk, so the net earnings are going to be based on what the other individuals are doing on that desk, but he's managing that desk. And Colchins found that that was significant. That was the Court of Appeals decision. In addition, there was a First Department decision in Friedman where an individual was tasked with creating these companies, divisions within a company, and the court in Friedman explicitly held that the plaintiff, so long as there are net profits, that would trigger the plaintiff's right to recover unpaid wages under Section 193. Unless your honors have other questions, plaintiffs rest on.
Thank you, counsel.
Brief.
Your Honors, if I could just respond to 3 points that were made in opposition. First of all, if the court finds that this payment was not a wage, then we don't even get to the second step as to whether the wholesale withholding of the wage is a deduction. And the test as to whether this is a wage is whether or not it was based on his personal performance alone or based on factors in addition to his own personal performance. And the claim here is that there was this, the allegation is that I'll pay you $250 if the LPC grants this approval tomorrow. So that's a factor outside of the plaintiff's personal performance. It's almost saying, I mean, if we win, I'll give you money, and if we don't, I won't give you money. So that's not based solely on his personal performance. And then the evidence is very clear on the record that there were at least 10 consultants and 3 employees at Parkview who were also working on getting this LPC approval in addition to Francis. So even getting that LPC approval was not based solely on his performance alone, but on other people's, which takes it outside of being a wage. 2 more points. Your Honor asked about whether the negotiation was continuing. Perhaps I missed the point of that question, but yeah, there's clearly the negotiation over this $250,000 continued after the hearing. Parties were exchanging documents for months, and Mr. Francis resigned from employment before the parties had ultimately reached the final terms of this agreement. That's in dispute, but that's our position on this, which takes it, again, if there's no contractual right, it's not a wage. And the last point about stare decisis, the legislature did pass the No Wage Loophole Act in 2021, and if the legislature wanted that act to apply retroactively, it could have done that, but it did not do that. And so there's no compelling justification for this court to reverse long-standing precedent, which Ryan does not require the court to do, because Ryan did not hold that deductions that wholesale withholdings or deduction from wages. There's no reason for this court to, compelling justification for this court to go back and reverse that long-standing precedent when the legislature didn't do that. Thank you, Your Honors.
People versus Salgado.
May I proceed?
Please proceed.
Good afternoon. Rebecca Besden with the Office of the Appellate Defender on behalf of Anthony Salgado. Mr. Salgado was induced by the court to take a deeply unfavorable guilty plea to the maximum legal sentence that he faced. He took this plea because the court improperly conditioned a significant evidentiary ruling on his upcoming trial that was about to begin.
Did the court condition the plea on that evidentiary ruling, or was the court just simply forecasting what the evidentiary ruling would be?
Well, Your Honor, the court explicitly made the evidentiary ruling a part of his plea package. I don't think it could be clear that this was part of the plea. The court's words were the
Which
promise.
is your position that if the defendant had in fact pled on his own, right, to bail jump, that the prosecution will be able to introduce evidence of the bail jump in the remaining prosecution?
Just quickly to be clear, it's inconceivable that Mr. Salgado would have taken this plea because it's to the maximum sentence. But to answer the court's question, this is analogous.
Well, wait a minute. Your statement there that it's inconceivable, not really, because if he doesn't plead, then the jury hears about the bail jump.
Yes, excuse me. It would be inconceivable if not for this linked evidentiary ruling. It's clear that's the only.
Right. So my question to you then, is there a universe, is there a world where you would agree that if the defendant pled guilty to bail jump, that the prosecution could still introduce the bail jump in the subsequent prosecution?
Well, the question there for the court to consider is whether this should be entered into evidence as consciousness of guilt evidence. And the prosecutor in the proceeding makes clear that the prosecutor thinks it should come in as consciousness of guilt evidence.
Well, consciousness of guilt is usually when you take flight from an incident, from a shooting, from something, not when you fail to come back to court.
Yes, but the key here is the court is not making that factual determination. The court is not doing the fact-specific analysis that a court should be doing to determine if consciousness of guilt evidence is admissible or not, which is weighing the prejudice.
You're overcomplicating this, right? It's simple. He didn't come back to court. Is that relevant to the underlying crime?
Well, the prosecutor argued yes.
I don't care what the prosecutor. Of course, they're going to argue yes, right? And you're going to argue no, and that's why we have judges.
Yes.
So he made a ruling. Basically, he said it's not coming in. If you plead guilty, it's irrelevant. It's not coming in. So how is that any different? Telling the defendant it's not coming in, even if he said it, you're going to plead guilty. You're going to get this sentence, and this is not coming in. That's a factual statement. I don't know how that's an inducement.
Your Honor, I think that it's helpful to analogize this to the situation where a court says, if you go to trial, I'm going to give you the maximum sentence of 25 years, and the offer is 10 years. You could say, well, yes, the court is entitled to sentence him to 25 years after trial.
Okay, so I pose to you, is the court entitled, right, to allow evidence of a bail jump after the defendant has pled guilty? Isn't it irrelevant to the other crime?
Well, again, that's a question of consciousness of guilt evidence. That's fact-specific. And the court here does not entertain that. The court says, my promise to you as part of this plea is you will do the maximum sentence 2 to 4, and I will not let this in.
Why is that bad? Why is that erroneous? Why isn't that a measure of, like an affirmation to the defendant? You're not going to, you can deal with one thing only if you go to trial on the robbery charge. You're not going to be dealing with bail jumping. You're not going to be dealing with absconding. There's going to be only one issue before the jury, robbery. That's it. Why isn't that an assurance?
Well, by taking its power to make evidentiary rulings in the case and using it to get the defendant, Mr. Salgado, to take a deeply unfavorable plea, again, to the maximum sentence that he...
Why is it deeply unfavorable? He got acquitted of the robbery charge. I would wonder if the result would have been the same if they had heard, the jury had heard, that this person ran off and was brought in only after the police found him.
Yes. And I think it's helpful to return to the threatening with the maximum sentence analogy. You could say that's beneficial. The court's giving the defendant this information. I'm going to give you this legal permissible sentence after trial. Knowing that, do you want to take a plea? But our courts have said, no, that is coercive behavior because the court should not be taking its power to sentence, its power to make an evidentiary ruling, and use that to induce the defendant
I have
to
a
take
question.
a plea.
And
Sure.
there are only a couple seconds left. If your client felt coerced, there was sentencing. Why not raise it at that time?
Well, here too we have a exception.
Lopez exception.
Yes, exactly. And I think it could not be clearer here from the allocution that Mr. Salgado felt his plea was being coerced because he gave clear indication that the plea was not voluntary, not once, but twice. And after the first time, when the court...
So it seems to me that the defense counsel didn't think this was a condition of the plea. Defense counsel said that afterwards, that he sort of projects what he's going to do forward, right? There's going to be a motion to eliminate, and you're going to prevent them from yes. That was the understanding.
Yes, well, that's following a bench conference, which is untranscribed. But the record is clear that this is an offer that came from the court. The court is the one that has the power to make an offer and combine an evidentiary ruling with it. Defense counsel doesn't have that power. And defense counsel and the court, after making this offer, that conditions the evidentiary ruling. Again, Mr. Salgado gave repeated indication again and again that the plea was not voluntary. He gave a sarcastic retort to the first question, which respondent concedes. Respondent concedes that the court recognized that that was a problematic answer and attempted to...
Can you finish up, counsel?
Yes, and attempted to rephrase the question, and Mr. Salgado again refused to answer. Nothing further, no further action was taken. Thank you.
Good afternoon, Your Honors. May it please the court. Jennifer Cavallas for the people. Defendant.
So it seems that if you just did a cold read of the record, right, that your adversary is correct. The court did say this is what you're going to get in return. Why is that not wrong?
Well, here, defendant's plea was not conditional on the court's offer or anything like that. This was a strategic decision that made a lot of sense when you look at the record as a whole. It was defense counsel first who asked for this arrangement after a sidebar. It was defense counsel who said, if he pleads guilty to the bail jump, then of course the bail jump will not be put in front of the jury, and it's totally up to him. The defense counsel himself, suggests that this is totally up to the defendant. And this came right after a suppression ruling where the people lost pretty much all of our case. The defendant could no longer be tied to the robbery. So now the people's case is really weak. Why have these cases joined together? Let's plead to this case. Let's go to the robbery and then be completely acquitted of those charges, because that's likely what's going to happen. You take the max on the sentence, because honestly, it's only a couple months different between the minimum and the max. It's 6 months on either end. And the judge, looking at the defendant's criminal record, he's got a pretty lengthy criminal record. He's got a violent predicate, robbery in the past, a couple misdemeanors.
Yeah, I mean, you're downplaying 6 months. That's a very long time to be in prison, right? But I guess that you're putting that against the prospect of him being convicted on the robbery.
Exactly, and the fact that the circumstances underlying defendant's history, the court was it's not surprising that the court would only accept a plea to the max here and not give defendant the minimum based on all the circumstances present. And turning to the comments that defendant made, first, as we noted in our brief, the challenges to the plea are completely unpreserved. But in any event, the totality of the plea colloquy completely supports that defendant wanted to plead guilty, that he understood what he was facing, that this was his decision and his decision alone. And yes, defendant did give a sarcastic offhand comment where he replied seriously, and the judge noticed this and rephrased the question, re-asked the question, and there was no answer recorded. The fact that there was no answer recorded is completely suspect when looking at this record. Judge Mendelbaum was very thorough, very direct, and very cautious throughout this plea colloquy and noted every little thing that went wrong and tried to fix it. So that one thing where defendant didn't answer is very strange in the context of the whole. And then going on, defense counsel never raised an objection. The people never raised an objection to not getting an answer from that. The court never said, wait a second, you need to answer my question. Nothing like that happened. So it can't be said that this plea was involuntary given the reading a totality of the record. If there's no further questions, we ask that you affirm. Thank you.
Thank you, counsel.
Just to briefly return to Your Honor's point about the couple months difference, as respondent characterizes it as, the maximum end of the sentence was a full year difference, the difference between 3 years and 4 years. That is an extremely significant time in an individual's life to be incarcerated. So we would take issue with that characterization. Regarding the preservation issue, respondent continually tries to suggest that Mr. Salgado's failure to respond in the record was an error. There's nothing to support that. First of all, if that was respondent's contention, respondent should have filed a motion in trial court. But moreover, that Mr. Salgado's failure to answer is exactly consistent with what happened throughout the plea proceeding, where first there's this eve of trial offer, which we maintain was improper, where the court conditioned a significant evidentiary ruling on the plea. Mr. Salgado is asked a first time if the plea is involuntary. He gives what respondent concedes is a sarcastic retort. The court recognizes that and asks a second question about voluntariness. It's hardly surprising that Mr. Salgado would refuse to answer that question. And these responses are in stark contrast to Mr. Salgado's answers throughout the remainder of the colloquy, where his answers are yes, sir, and no, sir.
Your suggestion is that when a defendant responds seriously to a judge, the judge is supposed to make further inquiry and what? Say, what do you mean by seriously? Are you challenging the court? I mean, where are we going with that?
Well, the court did make further inquiry here.
Yes, but in a very objective way that is very much in keeping with an allocution, right?
Yes, absolutely.
And it was appropriate. Judge didn't take the bait, is what I'm saying.
Well, the court, I agree it was appropriate for the court to rephrase the question a second time, but then Mr. Salgado failed to respond. And at that point, there's clear indication that there's an issue here. And the court should not have moved on with its colloquy. The court should have paused proceedings and said, what's going on here? You failed to say twice that the plea was voluntary. The court needed under Lopez at that point to conduct an inquiry, which was a requirement the court itself recognized by first rephrasing the question, but the court didn't get any assurance after that point. So the court was required to conduct an inquiry and did not.
Thank you, counsel. Thank you both.
Thank you. We would add.